Appellant Mr. Henry Okah's legal team came questioning the jurisdiction of the court to hear and adjudicate counts 1 to 12, as well as questioning the conviction on count 13 in accordance with the leave granted by the South Gauteng High Court. But with the leading of the panel of judges here at the appellate court, they got room to seek a little more than they came to seek. Henry Okah wasn't in court, but his legal team was. So was his wife, Okah, as well as some Nigerian officials. The arguments never got underway as the judges of appeal, led by Justice Mohammed Nafsa, made an observation on the presentation of the matter by the appellant's team. He noted that from court records of Mr. Okah's previous lawyer, Lokimana Tlala, a great deal of detail was provided regarding the difference between just wars or armed struggle and terrorism, as well as arguments over extraterritorial jurisdiction, but no constitutional challenge was properly presented regarding the statute being dealt with.
We've got a statute that's in place that Justice Claassen thought he was bound by. And what I'm putting to you is it your intention to continue to argue in the face of what I put to you, constitutional points that weren't raised in the manner in which they ought to be raised? Or would you want an opportunity to launch such a challenge and have this appeal pending?
Well, it's quite clear that those requirements wasn't met. If one accepts that in respect of the first 12 counts, all that one is dealing with on appeal is the question of the jurisdiction of the court. Now, doesn't that raise all kinds of difficulties for the appellant, absent a proper constitutional challenge?
We can't adopt a position in respect of it because it's not before us.
Well, I agree with you, Lordship, that the constitutional point, even if it's a good point,
yes,
has not been properly raised.
In less than 15 minutes, the judges laid two options before the appellant's legal team. Go ahead as is and face a mound of legal hurdles, or request a postponement in order to properly present a constitutional challenge.
You have one of two options. The one is to abandon the constitutional point because you've conceded it hasn't been properly raised. And the other is to ask for an adjournment in order to raise it properly. I'm just putting that to you as the two options that I see open to you in the light of your concession.
We'll apply for the postponement in this circumstance.
The wise decision was obviously to ask for a postponement sine die. We will supplement our arguments and we will include the Minister of Justice because it is quite apparent at this point that there is a constitutional issue that must be addressed.
The matter has been postponed sine die or indefinitely pending the time the legal team of the appellant will file supplementary heads of argument on the matter. From the Supreme Court of Appeal in Bloemfontein, the Free State, South Africa, Betty Dibia, Channels Television News.